In just a few hours, accused Charlie Kirk assassin Tyler Robinson faces a virtual hearing where a judge is expected to rule on several issues that could change the course of this case. That includes a request by the defense to remove the death penalty over a prosecutor talking to reporters, as well as the use of hearsay evidence at next month's key hearing to see if there's enough evidence to move forward. Fox News contributor and criminal defense attorney Josh Ritter joins me now. Josh, let's start with the sentence. I don't get this. I don't buy the defense's connection of something extrajudicial. In other words, the prosecutor talking to the media after the defense talked to the media and the prosecutor feeling they needed to clean it up. I don't get the connection between that and something that happens within the four walls of the courtroom, i.e., a potential sentence based upon the facts of a verdict. Does that make any sense to you?
Yeah, you're not alone in struggling to find the connection between the two. And it was a moment that kind of caught everyone off guard, because you're right. We're talking about whether or not there was this potential violation of the gag order, which is, I think, a weak argument to begin with. You're right. The prosecution was simply correcting the record. They weren't trying to influence the public. It's just there was this misconception about a pretty significant issue, and they were correcting that so that the media got it right. The defense jumps all over that, and then when it comes time for the judge to ask them, well, how do you want me to handle this? If I do find that there is a violation, what do you want me to do about it? And they say, well, we feel the only appropriate remedy is to remove the death penalty from the table. No connection whatsoever, kind of a non sequitur moment, but it revealed what it is that this is all about, that they're really just struggling at their very best to try to remove the death penalty from being a consideration for the jury down the road.
I'm still scratching my head. It was such a unique response that I don't think the judge is going to buy it either, but we will see today. Sticking with this for a moment, after the judge rules on this, is the defense done with trying to throw things against the wall to see if they stick, and other words, delaying this trial from happening further, or do they have something else up their sleeve at this point?
No, I don't think so at all. But buckle up. I think this is just the beginning of things to come. The other thing that's going to be ruled on today is whether or not that they're going to allow hearsay into the prelim. Now, thankfully, the judge seems to be sticking to his guns on keeping the prelim date when it's set for it, on July 6th. So hopefully we will all be watching that prelim that week. But as far as the hearsay, it has to do with a pivotal witness, his roommate, his romantic partner, Lance Twiggs, on whether or not he will be able to testify through a recorded statement. They're objecting to that. This is fairly routine to allow recorded statements to come in during the prelim. But I expect even after the prelim and every hearing moving forward until we finally, hopefully, get this trial, you're going to see delay, you're going to see obstruction, you're going to see them essentially throwing anything against the wall and seeing if it might stick, because I think they view that they're trying to save their client's life, and this is the war of attrition that they've decided to go with.
Just to be clear, I was going to ask you about the lover's statement that's going to be used basically as testimony. You do think that will be ultimately allowed in at the preliminary hearing as testimony? Just want to be clear on that.
I think so. I think the law is in the favor of allowing this to come in. They're trying to make an argument about confrontation, the confrontation clause of the Constitution, but we're not dealing with the trial, and that's the significant difference, is that we're dealing with the prelim where routinely hearsay is allowed in. In other words, if an officer had spoken to Lance Twiggs, and that officer was called to the stand and asked, what did he tell you, that would routinely be allowed. But for some reason, they're trying to draw a distinction because that same conversation happened to be recorded, and the prosecution simply wants to play that recording in court.
Yeah, a much lower bar for this preliminary hearing at the beginning of July. Josh Ritter, thanks as always. We appreciate it, my friend.
Thank you.
Be sure to like and subscribe for all the Fox News latest on YouTube, and catch full shows streaming now on Fox One.